What does reasonable suspicion actually mean under Tennessee law?
Reasonable suspicion is the level of evidence necessary for the police to lawfully detain a person. In Tennessee, in the criminal context, there are three main levels of evidence. First and foremost, the highest level, beyond a reasonable doubt, which is what is necessary to convict a person at a trial of a crime. The second is probable cause. It's the level necessary to arrest a person. Third, reasonable suspicion is the lowest of those levels of proof, and it's what's required to detain a person. Reasonable suspicion is defined as specific and articulable facts that lead the police to believe that a crime has been or is being committed. While lower than beyond a reasonable doubt and probable cause, it still requires the police have specific and articulable facts, which is more than a mere hunch that a crime has been or is being committed. And even once the police have those specific and articulable facts leading to reasonable suspicion, it only allows for a brief investigatory detention to either confirm or dispel those suspicions.
What are the most common reasons police claim reasonable suspicion for DUI cases?
So this is a two-part question. The first is reasonable suspicion for the traffic stop itself. The second is reasonable suspicion to prolong that traffic stop into a DUI investigation. So first, when we look at the traffic stop itself, speeding and failure to maintain lane are probably the most common as far as a DUI case goes. But then officers are supposed to write you a citation, let you go on your way. They're not supposed to just jump right into field sobriety tests. They need reasonable suspicion, specific articulable facts, more than a mere hunch, to believe that you've committed the offense of DUI in order to not just write you that citation and let you go on your way. So what do police look for? First is the phase one, the vehicle in motion. There's 24 indicators of alcohol or drug impairment that officers are trained to look for based on your driving behavior alone. But even still, they write you a citation and let you go on your way. Unless when they go to phase two, which is the personal contact phase, when they approach your window and start a discussion with you, do they smell an odor of alcohol? Is there slurred speech, red, watery, bloodshot eyes, unsteadiness on feet? Are there any bad admissions that you make that make them believe that not just that you consumed alcohol, but that you're impaired off that alcohol? So the second portion is there a reasonable suspicion to then prolong that stop to request you to do fields to go into phase three, which is the pre-arrest screening. And we highly scrutinize each one of those reasons that officers look at. Odor of alcohol doesn't mean that you are impaired, just means that you've consumed alcohol. Red, watery, bloodshot eyes, is it late at night? Red-eyed flights are called red-eyed flights for a reason, because they're late at night, not because everyone on the plane is, taking shots together and getting drunk. So there's a lot of issues that we look at, and we really break it down to see, does that give an officer more than a mere hunch, that reasonable suspicion to believe not just that you consumed alcohol, but that you're impaired off that alcohol? And so those are some of the most common reasons that are provided in DUI cases by police officers.
Can police pull you over in Tennessee without any reason at all?
No, police can't pull anyone over in Tennessee for no reason at all. They have to at least have reasonable suspicion that either a traffic violation's been committed or criminal activities afoot. Now, their suspicion doesn't necessarily have to be correct, it just has to be reasonable. If officers don't have reasonable suspicion to initiate a traffic stop, then that stop may be unconstitutional.
What happens if Tennessee police didn't have reasonable suspicion to stop you?
Yeah, so if an officer doesn't have reasonable suspicion to stop you, it can lead to the entirety of the arrest being dismissed. So reasonable suspicion is a complicated legal barrier to challenge just because the bar is incredibly low. Officers don't need probable cause, they don't need to be beyond a reasonable doubt, but they do have some standard, and that is clear and articulable facts that there's either an ongoing crime or that a crime has occurred in order to detain you or detain you while traveling in your vehicle. So it's a low bar for them to meet, but it is a bar they have to meet nonetheless. If an officer is unable to prove that, there's potentially a motions issue that we can file about whether or not the stop lacked reasonable suspicion, because if it lacks reasonable suspicion to stop you, typically it's also going to cause issues with the admissibility of field sobriety tests and any post-arrest statements, just because the initial part of the stop was invalid. So it's important for us to figure that out early, and that's why we're always so diligent about getting body cameras and dash cameras from the state to see if the officer's alleged reason for stopping or interacting or detaining you was actually a proper one, or was it something that just is contradicted by the video.
Can the evidence against you still be used if the original stop was illegal?
Generally, no. If the original stop was unlawful, then any evidence that resulted from that unlawful stop would then be suppressed and inadmissible to be used against you. This doctrine is called the fruit of the poisonous tree doctrine. This includes any tests, statements, searches, any evidence that resulted from the unlawful stop. That is why when we review cases, we always look at the initial traffic stop to see if it was lawful in the first place. The fruit of the poisonous tree doctrine is a powerful tool in criminal defense in that it may allow us to suppress incriminating evidence and in turn result in either a dismissal or a negotiated resolution with reduced charges.
Can Tennessee police search your car just because they smell marijuana?
Yeah, so really popular misconception, but the general answer now is it depends. Is the odor of marijuana alone is no longer generally going to be enough for an officer to get inside your vehicle. And there's a couple of reasons for that. So first off, we have so many CBD products that look and smell just like illicit THC marijuana, but ultimately can be perfectly legal for you to have. So there was actually a case named State v. Green back in 2024 in the state that determined that a canine sniff was not enough by itself to search a vehicle for the odor of marijuana. So if a dog's nose is not strong enough to differentiate between CBD and illegal THC, our interpretation of the court is that an officer's nose is not going to be able to tell the difference either. So one thing that we have personally seen officers, including in warrants, is now knowing that they need more, they're looking for whether you're nervous or whether you're making conflicting statements. But they're trying to look for something more than just, hey, I smell marijuana, get out of the vehicle, I'm going to search.
Is weaving within your lane enough for a legal traffic stop in Tennessee?
No, it is not. Weaving within your lane and even touching the line and almost failing to maintain your lane is not sufficient. You must fully cross over that line in order to be pulled over for failure to maintain lane. Why did the chicken cross the road? To get to the other side. And so when you're touching the line, it is not sufficient. The Tennessee Supreme Court has come out and said that no driver drives perfectly within their lane. And so it's okay to touch the line. You hear the da-da-da-da-da, and then you go back into your lane. It's not unless you fully cross over that line. And even when you do fully cross over that line, there are exceptions. The law says that you shall maintain your lane as long as it is practicable to do so. So if there are reasons for not maintaining your lane, such as a pothole in the winter in Tennessee, potholes are created, or a dead possum or raccoon in the middle of the roadway. You don't have to, run that dead raccoon over in order to maintain your lane. You're allowed to weave around it a little bit, and it doesn't provide an officer reasonable suspicion to believe that you failed to maintain your lane for a valid stop. An officer should continue to watch your driving, observe it, and see if you continue to have that issue persist. And if it persists, they probably should pull you over. But if you're merely touching in the line, it is not sufficient. Your defense attorney should get a copy of the dash cam if it exists and really scrutinize whether you cross that line. I've gotten cases dismissed at hearings from arguing touching versus crossing the line is not sufficient. It's been proven by the Tennessee Supreme Court. And so that is a heavily contested issue in DUI cases as well as drug cases across Tennessee.